All right, hi, welcome back. This is Copyright 3, Part 2. We're at pages 170 to 189 of our textbook. And we're still in this module on users' rights and defenses. And we're going to look in this specific section at two contexts, right? The two of the three main contexts where the Copyright Act gives defenses. And so says, even though you've infringed upon the rights of the copyright holder, we think there's good reason, and therefore no one can sue you for copyright infringement. Right? We're going to look first at some of the rights that are given to specific institutions, and then we're going to look at the common carrier exception. So you'll recall that I gave you, three main exceptions that we're going to look at in this module in more detail. We looked at freedom of expression previously, right? We looked at the defense of the public interest, and now we're going to look at three more exceptions in more detail, and these are specific institutions, right? Fair dealing, and common carriers. And as we're going to see, a lot of these defenses actually overlap. And so in some situations, right, an institution or a person that is being sued by the copyright holder for copyright infringement can actually claim that they fall under more than one of these exceptions. And that's especially the case for libraries and educational institutions, as we're going to see. Right? So in sections 27, right, to 33 of the Copyright Act, we have specific exceptions for libraries and educational institutions. These exceptions also cover analogous institutions, right? So libraries, archives, museums, and these sorts of institutions. And then the other category is educational institutions and similar institutions. Right? And these people are going to have specific defenses. So you recall, right, that users' rights are basically rights that we give people to use copyrighted work. And so usually, right, a use of the copyrighted work would be an infringement of the rights of the copyright holder. But in specific situations, we tell people either who have no rights or who haven't purchased the right to do something from the copyright holder, or people who've purchased a right but want to do something else with the work, that even though what they're doing would normally infringe upon the rights of the copyright holder, we're telling them it's fine because we create an exception under the Copyright Act. And the first one we look at, as I said, is educational institutions and libraries. What's important to understand here is that we're talking about specific users. So we're still under this conceptual framework, right, that I've just described of giving people excuses to violate copyright, basically. And in that case, what does it mean to look at libraries and educational institutions? It means that we look at, rights that are reserved to these people. And so, there are broad defenses to copyright infringement that apply to everyone, to any company, institution, or person, right? Like the fair dealing exception. The fair dealing exception is saying I'm doing fair use of your work, and that applies to everyone. Now we're looking at an exception that applies specifically to institutions. And so the exception we're going to look at gives specific rights to users that are libraries or educational institutions, not to anyone else, right? And as we'll see, who's an educational institution and a library? Well, typically that includes the entity itself, right? It's a legal person or a nonprofit that can be sued and that can do things that are, in violation of someone's rights. And as we'll see, that also includes people because of this idea of control. So we remember last week, I think, we looked at, this vicarious liability concept versus this criminal law concept, and we said that in some circumstances, right, you can be liable for the acts of another person, either because their actions are imputed to you even if you did nothing wrong, or because, right, you're considered to have been part of the plan and you're considered to have yourself done something wrong along with them. And again, because of this idea of control, the educational institution, for instance, exception is going to cover some employees of educational institutions that act for the entity and therefore are covered. Some people are not, right, because of the relationship of control, right? And essentially, right, you're given a lot of details that are not really that important, right? So you're told, for instance, that a student is not part of an educational institution. So we'll call these, right, the EI, as the book does, the educational institution exception, and the LAM exception, the libraries and museum exceptions, right? And you're told specific details about both of them. And the EI exception, you're told a student is not covered under the exception. A student is, has a contractual relationship with the educational institution. They pay tuition and they get a service, typically courses, exams that eventually lead to a degree. They're not covered because there isn't this idea of control. They don't work for the institution. They're not acting on behalf of the institution. And they have a contractual right. It's different from an employment control, relationship, similar to what we'd find in other employment contexts. Conversely, professors are covered by the exception because professors act on behalf of the institution, our employees are controlled, and so forth, right? You're told similarly for libraries and museums that clients aren't covered. The people who come in pay for a ticket, right? Well, they are related to the museum, but again, by contract, right? The sale of an item is typically a contract. It's beyond, the scope of this course, but there's all these foundational concepts from other areas of law that are helpful for us to understand what we're talking about in intellectual property law. When you buy something, you're really making a contract, right? Not really a written contract, of course, like your lease, and not really a verbal contract either, but more a contract that's represented by the transaction, right? For instance, I go to the barber shop. Well, I've accepted by virtue of sitting on the chair, right, the promise that's been made to me to cut my hair, right? So my hairstylist basically charges me $55 every month to get my hair cut, right? Well, I don't write anywhere that I agree to that. I just pay when I leave. Well, when you walk into the barber shop, right, there's an implicit offer because of what I've been told or because of my experience that I pay $55 every month. There's an implicit offer that the barber shop makes that they will cut my hair for $55. And if I sit on the chair and they start cutting my hair, I didn't agree to it, I didn't sign anything, but I've implicitly accepted the offer by sitting there, and therefore I am bound when I leave to pay, to do my part, to execute my correlative obligation under the contract, which is to pay, right? This is a mutual agreement where they cut my hair, I give them money. Exact same thing if I purchase a chocolate bar from the convenience store. By walking in, right, I'm not really doing anything. But obviously, when I see stuff in the alleys, right, with prices on them, that's an offer, right? They're saying this chocolate bar costs $2, and we'll sell it to you for $2 if you're willing to accept. And then when I take it, put it on the counter, I've accepted the offer, right? I've said I won this thing for $2, and then I'm bound to pay. I'm bound to execute my correlative obligation under the contract, which is to give them money, right? So the ticket holders of a museum, in the same way, are clients. They have a contractual relationship. They pay for the right? They pay for a license to enter the museum. They pay for the right to enter the property of another person, the museum, for a limited purpose, for a limited amount of time, and give money for that, right? So that's contractual relationship, and therefore museum patrons, the library patrons, are not going to be covered under the the library and museum, exception, because there's no control. The employees are going to be covered, the institution itself is going to be covered, but not the clients. And again, it is helpful to think of these things as Um, so you'll recall, backing up a bit from last week, that I made this hypothesis, right, that the money was really important, right? And so we made this hypothesis as to why is it that these various defenses apply, and what is the relationship between them, right? Because we have all those specific exceptions. And that's odd because in the first place we give a commercial monopoly to the copyright holder. We're saying you have an exclusive right to do basically most things with your work. But then we carve out these specific exceptions that say, well, in that case, even though you have an exclusive right, and we recognize that, there's an exception. And therefore, someone has a right to violate your right, your exclusive right, and we won't punish them. You won't be able to sue them and so forth, right? Well, I told you, right, that's my hypothesis, that the Copyright Act has a bunch of exceptions, right? We looked at 2 in the previous module. We'll look at 3 more in more detail. And as I told you, there's a big list of them under, I think, Section 23 of the Copyright Act. And what is it that ties these exceptions together? And I gave you this hypothesis, right? I made up this explanation that what I think is really going on here is that we're trying to protect the economic rights of the copyright holder. So you'll recall that copyright, I've repeated it on and on, copyright is only or mainly concerned in the central part of the regime, the protection of economic rights and not moral rights. And we also have this tension that I've defined many times between, users' access to stuff being in a public domain, people using stuff, reading stuff, coming up with their own stuff, and the protection of the legitimate interest of the copyright holder to make money with their stuff. And my hypothesis is that the various defenses and exceptions that we have, where we say that you can violate the rights of the copyright holder, where we say that the user has specific rights that they haven't contracted for, haven't paid for, and so forth, I think that's because these exceptions serve a different purpose. So A, these exceptions do not jeopardize the commercial monopoly of the copyright holder. And so they let people do things that are different, things that are not related and not in competition with the copyright holder having an exclusive right to sell their stuff and make money with it. Because the exceptions aren't about someone else making money with their stuff, and they're also not about someone trying to basically threaten that indirectly, right? Someone giving away stuff for free to people who would otherwise buy the stuff from the copyright holder. In fact, what they're doing generally under these various defenses and exceptions is entirely different. Not only are they not making money in the stead of the copyright holder, they're also not, doing things with people that would otherwise be part of the commercial monopoly, would otherwise do, whatever they do to the profit of the copyright holder. That's my hypothesis, right? And quite neatly, it applies here as well. And so you're told, right, that the 2 exceptions, right, which we cover as one, right, we call that the user's right for certain institutions. There's 2 categories of them, as I said, that are pretty broad. There's the educational institutions and the library and museums exception, right? And what are you told? Well, you're told these exceptions don't apply to all libraries, all museums, all educational institutions. And what is the limit? Well, you guessed it properly, it's the money, right? And so when does it not apply? Generally, and that's as much detail as you're given in the book, generally they don't apply to for-profit institutions. And so if you run a library for profit, you're not covered. If you run, a for-profit school, you're not covered either. And that fits neatly under my broader theory, right, that money is an indication that you shouldn't fall under the defense. Money is an indication that what you're doing either threatens the right of the copyright holder, or what you're doing doesn't form part of what we're trying to cover, right? And so, again, This is a more complex case. If I'm running a for-profit school, right, well, I'm making money. But I'm not making money from copyright infringement, right? So that's not really what justifies the exception. I'm not copying stuff and selling it. That's just downright copyright infringement. I'll get sued and I'll get into a lot of trouble. It's not really what's happening there, under that exception at least, right? The educational institution isn't necessarily, right, specifically violating copyright, but what we're saying is they don't benefit from that exception, right, if they are run for profit. And I think that even though that doesn't imply that they're making money from the copyright in that specific exception, my hypothesis is that that's because it's not the kind of stuff that we're trying to protect. And so even though the use they're doing is the same as a nonprofit library, they're not really the kind of people that we're trying to protect because they make money indirectly one way or the other. And people who make money, right, shouldn't be protected by the law in that specific instance. They should be, people should be able to sue them, recover from them, assert copyright infringement, and so forth. And we'll see that in a bit more detail as we go, right? So under this exception, right, you're told under section 30.3 of the Copyright Act, right, the law says that you can have some regulations, right? Who doesn't like regulation? Well, that's an enabling statute, and we have that quite often, right? And so in the simplest case, we'll have a law that's going to say what the rules are, right? But that's not necessarily flexible enough, right? Perhaps we don't want to write a statute that's going to be 100 pages long. Perhaps we don't know what the 100 pages should be about because we just came up with the idea of the statute. Or perhaps some specialized entity, right, like an administrative agency, is going to be more specialized than we are, right? It's going to have more experience with what we're regulating, and it's going to know better what the rules should be. And so what we'll do is in this statute, right, we'll put an enabling clause that says this agency or entity can make regulation about this. And that's allowed, right? If the entity just writes regulation, they're not valid because they don't have, right, an enabling right to do that. They haven't been enabled. And by default, under a constitutional system, administrative agencies don't have a naturally occurring right to make up regulation. But then the statute says, well, we're authorizing them to make regulation. And therefore, the regulations they're making are really pursuant to the statute. And so oftentimes, they'll have basically, for our purposes, similar authority, right? And what happened there after the Copyright Act said that, regulations can be enacted? Well, regulation was enacted that says you have to post this warning on your copying machine, basically, or an analogous thing. And so the educational institution exception is more complex. It's not complex in the Copyright Act. The way it's enunciated is pretty simple. What's complex is you have to respect the regulations because the regulations are now part of the Copyright Act. And to benefit from the exception, you have to respect the rules, and the rules are in the regulations. And they're complicated, right? You have to read them, you have to apply them. Typically, you'll hire a lawyer to do that. It'll cost you money, especially if you're a nonprofit institution. You'll have to print out the sign, make sure it's on there. If you have a bunch of libraries, you'll have to have, this manager of libraries that's going to make sure that the sign's on every photocopying machine at all time, and so forth. That adds cost, friction cost, right, to your compliance. And so as we'll see, it's not a very popular exception. Or at least, at first, institutions are going to try to fall under another one of the exceptions that are more simple to respect. And, I told you before that it doesn't apply to all institutions. We won't see that apply in greater detail, but I think it's important to mention it here. You don't have to split hairs over it, but it's important to mention it here. It doesn't apply to all institutions, well, it also doesn't apply to all works. And so, for instance, right, under section 30.2, right, the exception is not for fiction work. And that's pretty important. So even though it's an institution that's covered, right? First, the institution can be for profit. And second, the specific work that is concerned, right, the work that, say, we're making copies of as a library, has to be a work of a certain nature. In that case, has to be basically not fiction. So it has to be, research paper or a newspaper or something else, not just a fiction book. And so that's just for information purposes. We don't see it applied, so it's not important to learn that in great detail. But there are some limits on that, because we're carving out this specific exception that only applies to a certain type of users, and therefore we try to have rules that limit its scope. So you're given in that section, right? We get back to the Law Society of Upper Canada case, right? And so what does that case say? You'll remember it because I summarized it about 4 times in the course, because they like to give you the same cases, but give you different sections of them that address different areas of the laws you're learning them. So Law Society of Upper Canada summarized it in the previous capsule, so I won't repeat it entirely. But right, they have this service basically run by the Ontario Bar, the Law Society of Upper Canada, now the Law Society of Ontario. They have this library where you can get the legal sources. And you can either go there and photocopy it yourself, or they can make the photocopy for you and send it to you, right? And then the question arises, well, what if someone infringes copyright? What if someone asks for something that is copyrighted? Because obviously the library, what they're doing there is they're trying to help lawyers or other people do their research. And so they won't systematically police whether you're asking for too much of the book, right? They would need a full-time lawyer to start looking at every request and say, well, this is 10 pages, but it's 10 of the not so important pages, and so therefore my legal opinion is that this is not a substantial part of the work, and we're good. Obviously, the Law Society doesn't do that, and most, educational institutions or libraries won't be expected to do that. Then someone sues the Law Society for copyright infringement, oddly enough, before there's even any copyright infringement. Someone said, well, you put this sign on your photocopying machines that say, if you infringe copyright, we ain't responsible, and that's you recognizing that someone's going to infringe copyright. Court says no, right? What are the exceptions that apply here? So, obviously, we could apply this exception there, right? The educational institution exception, or the library exception, depending on the type of institution. But, as I told you, it's complicated because you have to respect all those regulations. So what happened in the Law Society of Upper Canada case? Well, the Law Society didn't try to use that exception. They used the fair use exception in the section you're given. And the fair use exception, right, which we don't look at in great detail, but which we mention a bunch of times, is this catch-all exception that covers stuff that is not commercial. So covering something on the news, playing a video to make fun of it, putting parts of someone's work to analyze it, criticize it, for instance, in your research, and so forth, right? Well, what's happening here? The patrons of the library, the lawyers, are doing something that is at first sight protected by fair use, which is research, right? Research is one of these exceptions. You don't have to learn the full list. Just having a general idea of fair use is fine, right? Fair dealing exception. So, the patrons of the library do something that's protected. So even though they might be photocopying a book, right, which is a copyright infringement if it's a substantial part thereof, if they're doing it for their own private use and for research purposes, they're good. But the question that arises is, well, what about the library? And that's important, right? Because if the library were doing that, they could claim the exception. So you recall this idea of control. So what if it's an employee of the library that's doing the copying for the library. So the library has, whatever it is, does research to see if it complies with the law. Well, then the Law Society commissions an employee and tells them, go photocopy me this case law so I can decide whether I'm complying with the law. Then the employee is an agent of the library, and therefore the library is the one the actions are imputed to. And so the library itself can claim the exception. Just like a person doing research can claim the exception. An entity like the library doing research can claim the exception. What's happening here, right? Not that. The library isn't doing research through its employees for itself. It's doing research for other people. And these other people, presumably, are covered by the fair dealing exception. Right? These other people are asking for parts of books to do their legal research. It's covered. What if they don't? Right? And what is the role of the Law Society as an intermediary? Right? The Law Society in that case is just in the middle. It's not the copyright holder, and it's not the person doing either the use that is subject to an exception, the fair use, and the library is not either the person that's hypothetically infringing copyright. And what does the court say in the Law Society of Upper Canada case? The court says, as I just said, obviously patrons are not employees of the Law Society of Upper Canada, and therefore the Law Society doesn't claim the exception for itself, but if it's helping other people doing fair use, it's fine, right? And so if you provide the means, if you provide a photocopying machine, but even if you do more than that, even if you, actively photocopy stuff at the request of the patrons, if the patron is conducting research, which is covered by the fair use exception, you're also covered. And as we said, it applies in the converse case as well for different reasons. So because you're an intermediary, and we looked at that previously, so we won't get into it in great detail, but you'll remember that because you're only an intermediary, like Facebook, like a park, the photocopying machine's the same. Because you're only an intermediary, you're not responsible either if the person does something wrong, as long as you're not in the plan. And so as long as you're not doing something specific to help them infringe copyright, you're good. So that's the preliminary case that you are given, right? And what they tell you is the Law Society of Upper Canada could have used the educational institution defense or exception, but it did not because another exception was available. So as we said, that shows that the defenses are overlapping, and oftentimes, a defendant is going to claim more than one of the exceptions. And as we said, this exception we're looking at is particularly complex to respect, and therefore it's not going to be very popular, right? So what did the Law Society do? It used the fair use exception successfully, right? Or the intermediary exception successfully. That's what happened in that case. That's a different defense, right? And again, we looked at that previously, so we won't get into it in great detail. But you're told that the same thing is true if you are, if you're, say, a professor. And so if you're a professor that's, sending research materials to your students, so you're copying copyrighted work on behalf of someone else, same thing is true. You should be good because, you're helping someone do a use that is presumably covered by the exception, right? And that is enshrined in the specific exception that I told you in the previous module was added more specifically in 2012, right? So in 2012, we had an amendment to the Copyright Act that basically said what? Well, it said that they that educational institutions are specifically covered under the Copyright Act, under the fair dealing exception, sorry. So the scenario that I just gave you, right, where an educational institution is basically helping someone do fair use, well, the government said more specifically, the court had already said it, but the government said it specifically, that educational institutions can claim the fair use exception. And so they're not restricted by virtue of the fact that they're an educational institution to claiming the educational institution exception. That's it. And so this is not the most important exception because it's not really covered in the textbook. You're given the details of it. You're given a case of the Law Society of Upper Canada to contrast the exception, but admittedly, you're not given a case where that exception is specifically applied, at least not in that section, and you're told basically how it would apply if a court were to apply it. That's the first exception we look at. The second exception we look at is the common carrier exception. And that's again an exception that we have looked at before in some detail, right? Common carrier, what does common carrier mean? Well, the operative word there is carrier, right? And so someone who is an intermediary, someone who is not the person talking or the person listening or the person whose rights are being infringed, someone who's just stuck in between. Maybe like the Law Society of Upper Canada, right? What if I'm talking over the telephone and I tell someone, hey, we're going to commit this criminal act? Well, obviously, I've done something wrong. The person presumably did something wrong, but the telephone didn't do something wrong. The telephone, was implicated in my prospective crime because the telephone heard what I said. And my telephone company, right, my Bell Canada, retransmitted that. And so it went through Bell Canada, right? Bell Canada made a decision, essentially, to take my criminal words and send them to someone else. And so is Bell Canada part of the conspiracy? Well, the answer is not. And why is that? Because common sense, or more specifically, because Bell Canada is just an intermediary. Because Bell Canada only carries the signal. They don't listen to it, they don't analyze it. And so Bell Canada doesn't really know that I'm using criminal words. Because Bell Canada has all those communications every day, and they don't have someone listening to every phone call to see if there's a crime that's being discussed. And in fact, it would probably be bad if they were, not just for privacy issues, but also because that would cost a lot of money, and that would increase the cost of the service. And therefore, the intermediary, as we said, that is content neutral, the intermediary that is basically transmitting everything without regard to content. So it's transmitting all the phone calls, not just the non-criminal ones. It's transmitting all the phone calls and doesn't even listen to them, is not responsible for the infringing action, right? And we have, again, under this, the Society of Composers case, which we've read before. We've read a different part of it before, which is this Supreme Court case, which looks at, well, how'd you apply this? Right? Because what I just said about the telephone is pretty well established. And why is that? Because we've had the telephone for a very long time, and the courts, even though they have a lot of old people on them, understand how telephones work, and it's not really that, new, and we've had times to come up with these rules. But then what happens in the 1990s when people come up with the internet and start using it massively? Well, we don't really know how the exception applies. And so the Society of Composers case basically asks the question, how do we apply this common carrier exception? This exception that says the carrier, the intermediary, is not responsible to an internet intermediary. And by default, right, there's no reason to think that it doesn't apply. If it's phrased broadly, right, there's no reason to think that the exception doesn't apply to new types of carriers that were not foreseen when the law was written, because it's a general exception, and it doesn't matter that we came up with the idea afterwards, right? And what happens, right, we have a bunch of different types of internet providers that help us understand this common carrier exception. We have, we'll write them out this way, it's going to be simpler. Right, so what about the host? So you'll remember I already gave you this example, right? What if we have a website where people upload things, download things, generally, legal things, and the website doesn't do anything. The website doesn't police the content, and they're not expected to. Well, obviously, as I told you, eventually someone's going to upload something there that violates copyright. And what do we do with that? Do we hold the website responsible? Again, conceptually, the website's in the middle there. You've got the person posting the stuff, right, that is copyright infringement. You've got the copyright holder. Or you have the user who's downloading it, and you have the copyright holder whose rights are being violated. And again, in the middle, right, you have this intermediary. You have the website. The website is enabling this, right? None of this would have happened without the website. That's true. But it's also true that the website doesn't actively do anything, and they might not even know or look at whether what you're doing on there is protected by copyright or not. And so, what does the court say? What about a host? Again, a website that hosts content. Basically, the example I just gave you. Can that website be held to violate copyright or not? Right? And in that case, we were concerned specifically with communication to the public. So you'll recall that the exclusive rights of the copyright holder that we saw in greater detail includes the right of performance to the public. That's one of the rights, right? The main one that we often see in the case law is reproduction. If I reproduce something, that's a violation of copyright generally if it's a substantial part thereof. Another right of the copyright holder is performance in public. And you'll recall that I told you this is a compound phrase. And so it's performance in public. Performance doesn't cut it, has to be in public. And that's an exclusive right of the copyright holder. What does that mean? Well, it means if someone is doing performance in public without the authorization of the copyright holder, you're violating an exclusive right of the copyright holder. So, in that case, we have the host, right? And so we have this person right here who's violating this right. And then we have this other person, and there's a bunch of them, right? Let's say there's 100 people there. And so someone mischievously decides to post copyrighted content on the website. It's bad. It's copyright infringement. And so someone, sits in their living room. They watch a movie, and then they start recording it with their telephone, and then they put that file on the website, right? And then, assuming the website is public, what happens? Well, people who visit it can download the movie, right? The illegal copy of the movie. And again, it doesn't really matter how many people download it. It doesn't have to be, humongous numbers of people for it to be performance to the public. It's more a virtue of the website itself. If the website is publicly accessible, that's to the public, right? Even if no one cares, even if no one goes download it, as long as it's to the public, that's kind of where the analysis happens. If it's not a private website, by virtue of how the internet works, it is public, right? And what happens there, as I said, that person is violating a right of the copyright holder. They're actually violating two, right? They did a reproduction, but what we're concerned with here is performance in public, right? Because what they did there is they posted the video to the public through the website. And so they used the website to disseminate the video to the public illegally. And that's a violation of the copyright holder's exclusive right to performance in public. The question is, in the cited composer's case, what happens with the website? Is the website responsible? And the answer, to make things simple for a 10-page case, is no. Because the website didn't do anything wrong, it was just there. It wasn't a website that was, copyrightinfringement.com, where they told people, come here, post your illegal stuff, and people are going to be able to watch movies for free and it's all going to be great. That's not protected because it's not content neutral. Let's say the website is Facebook. Well then, Facebook, right, isn't a website about copyright infringement. It's a website that's content neutral. And where someone posts something that is copyrighted and that constitutes performance to the public. And what happens there, the court says the host is not responsible. So they break it down, right, at paragraph 29 of the case, right? They give 4 questions. One of them doesn't matter. First question is, when does a communication to the public occur on the internet? When does it occur? Does it occur when a person posts it, when the website publishes it, or when the person, the public, a person of the public watches it? The answer is when the person posts it. That's the first issue. And so when they post it, it doesn't matter that people might, obviously not watch it all at once. They'll watch it at different moments. That's still to the public, even if it's not, strictly simultaneous. And it's also, a performance that occurs for copyright purposes when it was posted. And so when a person posted the video, regardless of when it was watched, that's when the person did the infringing act. That's when the person did the communication to the public that is covered by the copyright regime. Second, who communicates? And as I said, the court says the person communicates. The website doesn't. Regardless of how the website works, even if the website is retransmitting, even if the website is saving a copy, it doesn't matter. That's just technology, and the court doesn't really care, right? Doesn't care how the website works. They can have a copy in a different country, whatever it is, doesn't matter. The website is really acting as an intermediary. So even though the website might work differently than a telephone, right, than a traditional means of communication, work differently than a satellite on a television, it doesn't matter. And even though the intermediary might work differently in a way that kind of has us scratching our heads, right? Because if they make a copy, that's kind of concerning because, it's different from the telephone, but also copy is reproduction, and so, not sure. But does the court say, don't worry about that. They can make copies however the internet works. What matters is, in a broad sense, they're acting as intermediaries, and so they can claim the common carrier exception. Third issue. So first one was, when does the communication to the public happen? Second issue was, who does the communicating to the public? We answered that. The third one is, when does the act of authorizing a communication occur? So when's the website in the plan? And the answer is, by default, it's not, as we said. So by default, the website that is content neutral will not be, stuck in a copyright infringement lawsuit unless, right? Unless we looked at this system of takedown notices last week, I think, where we said, yeah, the website's not responsible, but once it knows, it does something about it, right? They're not responsible, as we said. The rationale for that is arguably that the website doesn't know. The website doesn't police the content, and therefore, right, they're not responsible. Well, once they know that there's copyright infringement, the rationale doesn't hold up. And so if someone tells them, hey, this is my stuff, it's copyrighted, then the website has to do something about it. If they don't, they're in the coup. They're responsible for copyright infringement, right? We look at this system of takedown notices. Generally, the copyright holder is going to send a notice to the website that says, hey, this is my stuff. And then the website is going to, communicate with the person who posted it and say, hey, take this down now. Or we'll take it down themselves. That's why it's called a takedown notice, right? And so when does authorization occur? Typically, authorization doesn't occur right? The website isn't part of the coup unless there's specific circumstances where it knows or is participating. That would also be true in the example I gave you of my website called copyrightinfringement.com, right? Well, if I'm creating a website called copyrightinfringement.com, then I'm initially authorizing copyright infringement, right? I know that copyright infringement is going to happen because my website is not content neutral, because my website is for copyright infringement, and therefore I'll probably be responsible for all copyright infringement that happens on my website because, I'm in the coup for all of those various infringing acts that happens. And the court basically answers the issues this way. So who communicates, when does the communicating happen, and 3, when is the website in the coup? Fourth issue is, when does the communication occur in Canada? And the answer is, good for you, you don't have to worry about that. And so you're given this very detailed analysis of, who's in Canada, is the communicator in Canada, is the consumer in Canada, the user, is the company in Canada, what if then the server, the host is elsewhere? Don't worry about that. For our purposes, we won't get into jurisdictional boundaries. We'll keep this simple. And essentially this requirement was either watered down or completely removed by the court eventually, so it doesn't even matter anymore. But for your purposes, it doesn't matter at all, right? So you don't have to worry about the stuff happening in Canada or not, even though it's discussed in the case. And we'll look at some more specific phrases by the court, but the summary I've just given you is the important issues that are covered in the case. The court says, well, what is an intermediary? Paragraph 32, an intermediary acts as a conduit for communications by other persons. The website's covered because it's a conduit for that, right? And you're also told, as I said, when it's not content neutral, they're responsible. And the court gives you an important caveat there at paragraph 32, but also later on, that says basically, what if they do something that is not okay? So in my example, what if Facebook, has someone who infringes copyright on the website? As we said, by default, they're not responsible, right? But then what if they get a takedown notice? Well, as we said, if they don't act on it, right, which doesn't necessarily mean taking the content down, just means being reasonably diligent, right? They can investigate it and find that the copyright holder lied, but, they have to act upon it one way or the other, look into it, be diligent, right? So in that case, if Facebook doesn't do that, well, Facebook's responsible for copyright infringement with the person who did the copyright infringement. So this person is responsible, the person who posted it, to the copyright holder, and the host is as well, right? But the court says, does that mean that suddenly you can sue Facebook for all communications? And the answer is more complex than that, but for our purposes, the answer is no. And so Facebook, having some activities that are not content neutral, doesn't mean that all of Facebook activities are suddenly going to no longer be covered. So Facebook is going to be responsible for that specific business it has, or that specific act it let the infringer commit. But that won't mean that Facebook is going to lose the benefit of the common carrier exception entirely. So that's the answer that the court gives at paragraph 32 and also later on. And so again, as I said, this issue of what country we're in doesn't matter. Paragraph 38, we have this idea that in the statute, right, that it has to be a necessary means of communication. How does the court interpret that, right? Necessary sounds like a pretty high threshold, but the court says, well, not really. And so the website is an intermediary because it's an intermediary. What happened was, right, this is a Supreme Court case, if my memory serves me well. Yeah, it's a 2004 Supreme Court case. So what happened, presumably, is the Copyright Board, which is the specialized tribunal, made a decision, right? Then they went to appeal to the Federal Court of Appeal, I think, and then they went to the Supreme Court. And someone down there said necessity is important. And they did something that's a big no-no. They said, well, necessity means, right, that it would have to happen even though there were no technological means. And so what Facebook does, right, is not necessary to the communication unless it would also be what a telephone does. And the Supreme Court says no. Necessary is not that. And necessary isn't absolutely necessary either. Necessary is just, necessary in that it's the means of communication. It's necessary to the communication, but the threshold isn't higher because we use that word that seems a little bit high, a bit of a high threshold, sorry. Also, at paragraph 40, right, I'm going to say this on and on because it's important, the court does what it always does. It invokes the purpose of the copyright regime, which hopefully you know by heart by now, right, which is to balance the public interest in accessing stuff and promoting, the activities that happen through work in the public domain, and balancing that with the legitimate right of the copyright holder to make money, to profit from their work, and to have a commercial monopoly on it. And in its analysis, the court invokes that and says, well, the solutions that we give you here as a rhetorical device are correct because they affect this good balance. And other solutions are wrong because they don't. That's what the court says at paragraph 40, right? And the court says this balance is important to affect in the context of technology because otherwise people are going to be stuck, right? Innovation as well is going to be stuck, right? So companies aren't going to create websites if they get sued all the time, because that might mean they'll go bankrupt, or it might mean that the existing companies end up going bankrupt because they get sued all the time. And that would be bad because it would prevent technological innovation. That's essentially what the court says, right? And the court says it's in the intent of the statute that we define in a broad sense what necessary means and what the common carrier exception covers. So not just the means of telecommunication, but in the context of technology, websites as well, and so forth. And I'll tell you something that is, and as well on that issue, before we move on, at paragraph 101, the court gives you this example of AOL, right, which was this cool website back in the days when you probably were not born. And the court says America Online, AOL, delivers in the order of 11 million transmissions a day. And why does the court say that? To reinforce what I just told you. It does not police these 11 million communications, and it cannot, like Bell Canada. And as a matter of both statutory intent and good public policy, right? As a matter of what the statute says, what the government says is its intent, and as a matter of, favoring a good solution, it shouldn't have to police this stuff because it can't. And if it had to, it would either go bankrupt or have to hire a bunch of people and then charge a lot of money for the service that it's offering to transmit communications. And the takedown notice system is also discussed at paragraph 110. Then the court moves on to this second issue of a cache. And what's a cache, right? It's a copy of a website. Essentially, I'll admit I don't really understand this too well myself, but for our purposes, you just have to understand it as well as the court does, right? And basically, it's a copy of a website. So someone's going to have a copy of a web page somewhere. So it's not just you accessing something on the internet. There's a physical copy somewhere, either with the host or on your computer. And then the question is that an illegal copy, right, under the right to reproduction, which you might be violating? And second, are you in the coup because you got a physical copy, because it's cached, right? And, does that make it therefore different from a telephone, for instance? And the court says no. For the same reasons I've given you, I won't repeat them. Paragraphs 113 and following of the decision, right? Court says, well, again, this is just how the internet works. And it doesn't matter that it's different from a telephone. It doesn't matter that we're worried about a physical copy. It's an intermediary. However it works, it's covered. It's basically what the court says. Now, before we move on to the next case, I want you to think a bit more critically about this, right? So we looked at the case. That's what the case says. Admittedly, pretty simple. Gives you a good definition of the common carrier exception as applied to more modern technologies and contexts. What I want you to think about now is that true now? Right? So we'll look at what the court said again. So this is a case, as I said, from the Supreme Court, right? It's an appeal of a decision, presumably of the Copyright Board. And that's a case, right, from 2004 from the Supreme Court, right? Since then, AOL is no longer the way we communicate. And so things have changed. And I want you to think about, right, you might want to write a paper on this, whether that is still true. The court says, right, that we want to favor this. And one of the reasons for this is that it's good public policy, right? It's the right way to interpret things to give effect to both technological innovation, which helps users access stuff, and to give effect, to this balance with the right of the copyright holder. And it's a good way to ensure, right, that technology doesn't upset this balance or the entire regime. And the other reason for this is not just that it's good public policy, it's that it was the legislative intent. And so if the government says in the law, either explicitly or implicitly, we really like technological intermediaries, we really don't want them to go bankrupt, we really think that they shouldn't be regulated or should be regulated as little as possible because we don't want them to go bankrupt. Then, it's not really a matter of public policy only, because the court is bound by what the statute says. And if the government evidences its intent, in that case to have intermediaries covered by the common carrier exception, in that case, right, the court is kind of has its hands tied. I want you to think about a different context. What if there's no legislative intent, right? What if we take this, in a different setting, this not 2004. What if we take what the court said then and think about whether it is still appropriate? So the court says, I'll read you two passages, and I want you to think about whether that's a legitimate justification, whether that's a justification that holds up to scrutiny today, not in 2004, and not assuming that Parliament said it. Just assuming that that's a justification that a court comes up with that can be questioned because it's the court that came up with it, not Parliament. Paragraph 114, right? The public interest to encourage the expansion and improvement of the operations of intermediary without the threat of copyright infringement. Again, this rationale of people going bankrupt that I just gave you, or of slowing down innovation. More importantly, paragraph 131, right? We don't want disputes to be had between copyright holders and intermediaries because their, and I quote, continued expansion and development is considered vital to national economic growth. That's serious language. What if this is not the intent of Parliament? What if that's not self-evident because it's written down? Is that still true today? I'm not sure it is. I don't know that I can give you a definitive answer on that. You should probably think about it and phrase your opinion, but I'm not sure that it is. And why is that? Well, we don't have issues today with wanting the internet to be developed. The internet is everywhere, right? There's some of the biggest companies in the world, right? Google, Amazon, Facebook, Apple, all of these companies are some of the most, high-performing stocks on the stock market. And the most highly capitalized company in the world, which is Apple, right? In the United States, the most valuable company is a tech company. So obviously, right, it's not like we want this new internet thing to take on and save our lives. To a large extent, it's already done, the benefits that it was supposed to bring us. Right? There are further benefits, of course, with its development, with the development of technology more broadly, but in terms of wanting websites to become popular and develop, I don't know that justification is still true today. Right? Maybe when AOL was there and few people were using computers at home, maybe then it was a national economic growth imperative, as the court said. But I don't think it is now. And the second thing that I want you to think about is the extent to which this argument relates to what I said before about making money. Right? And in that case, it applies in a certain way, right? Because the host is just providing a service. They're not making money from the copyright infringement. The person who's infringing might be, but the website isn't, right? Facebook doesn't make more money because you're infringing copyright on Facebook. But I want you to think about what I just told you, that the tech companies are some of the biggest, most profitable companies on the planet. Well, in that context, what are their obligations? And my hypothesis, right, again, you're allowed to disagree with me vehemently, is that perhaps we got the balance wrong. Because it is true that the hosts don't make money from copyright infringement. It might be true that if the hosts could be sued indiscriminately for copyright infringement, that would be bad. That would, jeopardize their existence. Maybe. But they do make money, right? Facebook makes money. Facebook makes, $20 to $40 billion a year by putting ads on that. And so they're not part of the coup. They don't make money from copyright infringement. But should they have obligations that are tailored to, their profitability, right? If a company has a monopoly on all communication, so unlike a telephone, right, there's a lot more communication that happens on Facebook than there is on the telephone or in a park. And in that world, to what extent, if Facebook makes money from that by serving you ads, and a lot of money, to what extent should we question this indiscriminate protection from liability of the common carrier exception? And I would suggest that it might be worth questioning, at least to some extent. And that's also true because, totally unrelated context, but as I'm recording this, it is January 11th, and the United States president recently got banned from Twitter. And lots of people thought that was a very good idea. Lots of lawyers were worried about a bunch of things, happy about a bunch of things. I won't tell you my opinion on that, but I want you to think about what it means, right? And to me at least, I think an important issue is, and we saw that already, an important issue is that if the president doesn't communicate there, he's going to communicate elsewhere. And on Facebook or on Twitter, right, there is a certain diversity of people who consume content. And so one of the consequences of banning the president on Facebook is he might go on a right-wing website, say, that only has a supporter. And that might be bad for democracy because these right-wing, consumers, of right-wing content, which is fine, people can consume whatever content they want. There's also left-wing content, but people who consume that are much less likely than on Twitter, say, to be exposed to the views that are different from theirs. At least that's what I think. So that's a concern. And we saw basically, right, that the president tried to move to something called Parler, which is an app that was, basically the following day suspended by Google Play and the App Store, which means, essentially it's a threat of going out of business now because it's an app that essentially was used for planning the Capitol attack, and that, in their opinion, is a forum for alt-right people. And again, I want to be careful about talking about these things. I'm not phrasing a definitive opinion. I understand this is a very sensitive topic. I couldn't work that day because as a lawyer I felt personally affected by this and didn't know how to react. So I want to mention that I take this very seriously. But as I said, one of the concerns, might not be the prevailing concern, but one of the concerns is if you ban the president from Twitter, he might go somewhere else, and people might go somewhere else with him, and that might add to the divide between views in a country and people not being exposed to more diverse views. The second thing I want you to think about, right? Again, this is just my opinion. It's not going to be on the exam. Second thing I want you to think about is the extent to which that tells us how much of speech in the modern world happens on the internet, right? The president's Twitter account had, I think, 88 million followers or something in that order. And the president's tweets have been covered by the news for years, right? It's an important place where speech happens. And to a large extent today, it's the most important place where speech happens, right? People don't talk in a park or on television as much as they talk and hear from others on Facebook. And so the question might be asked, and it's being asked, and Facebook is different because it polices some content. Twitter does as well, but you know, they were called before Congress essentially because the Congress felt that what they were doing was either biased or that they weren't doing enough. I want you to think about how the common carrier exception should apply here. And to what extent should we have, that's just food for thought, obligations of these companies? If all of the speech or most of the speech happens on the internet or on Facebook or on Twitter, how should that change the obligations that we impose upon these companies? And to what extent is the common carrier exception still relevant today in that context? Even though that context doesn't directly challenge the justifications that I gave you for the exception, to what extent is it good public policy in a world where most speech happens on the internet? And second, perhaps think about where the public divide, the public-private divide exists, right? If someone is talking in a park, the government can regulate their speech because they're doing it in a public place. And we won't get into the nuances between Canadian and American constitutional law, but basically what the Supreme Court of the United States said, different in Canada, but anyway, the Supreme Court of the United States said is Facebook is not responsible for what it polices. And so Facebook could technically, as a non-public place, right, censor whoever it wants because it's not a public place. And I want you to think about not just what obligations we should have on companies where most of the speech happens, but also the extent to which it should be these companies regulating themselves or not. And I think that's an important question in contemporary North America and most of the world, right? Because what's happening is people are doing most of their speech not in a park, not in a mall, not in a public place, but on Facebook, which is owned, regulated, and Twitter by a private company. And to what extent should we change the rules and say the government, right, should be regulating what happens there because it's a public forum? And in the United States, to a large extent, the government has not done that because of how the Supreme Court of the United States has interpreted what Facebook and Twitter are. So that was just food for thought. Again, just my opinion. And I want to reiterate that these are sensitive issues that I try to discuss mindfully of the impact the attacks on the Capitol and the banning of the president had on people, including people who have diverse political views, including people who might have supported the president for that reason or another. So the second case that we have, right, so we looked at the Society of Composers case. I gave you all this food for thought, right? Then we have a contrasting case, which is the Bell Canada case. And again, right, we're using the common carrier exception. And what happens in that case, right, you have these people who create this hardware, right, these boxes that you put. And with these boxes, what you can do is you can access stuff illegally. So you'll buy the box, right, and then you'll be able to mischievously access television shows and movies for free. And in that 2016 case, right, the federal court says, well, is an injunction going to be issued, right? What's an injunction, right? An injunction is someone preventing someone else from doing something. Again, that's beyond the scope of the course, but they're fundamental principles that are helpful to understand. So, I'll sue someone for copyright infringement. I'll get a trial date if it's urgent a year from now at the federal court. What happens in the meantime if the person infringes my copyright? Because I don't have a right for them to stop doing whatever they're doing until I've won. So for that 1 year period, they'll do whatever they do. Injunction, right, helps prevent the situation where something really bad is going to happen in the meantime. What if someone infringes my copyright and by the time I get to court I'm bankrupt and it's too late? Well, then I can ask for an injunction before the trial that is going to tell the person don't do it until the trial. And the standard is high because you are basically preventing someone from doing something before you've proven definitively that it's illegal, right? It's kind of like putting someone in jail while you're investigating them, right, which we do in this country. That's tricky, and the standard has to be high because people have a right to do things, and you're preventing them from doing them before someone else has proven definitively that what they did is indeed illegal. And so the injunction, you have to prove a bunch of things, right? You have to prove your prima facie case. What does that mean? It means you're pretty likely to win, so it's a higher standard than we're pretty sure. It's a standard where, we're almost sure that you're going to win, right? You have a very strong case, and you have to prove the balance of convenience, which we won't get into, and irreparable harm. So as I said, generally what that means is me going bankrupt. So generally harm that cannot be compensated by money, because what you get in court usually is money, is damages, and if when I win, the money isn't going to repair the harm, that's irreparable harm. So we have these people who create these little boxes where you can access stuff for free, and then, right, Bell Canada says, whoa, that's not fine. These people are accessing our stuff, right, our content illegally, and the people that are making the boxes are helping them do that. And that's bad. They should stop doing that. And so they go to court and they ask for an injunction. And on the high standard, what happens? They win. And so the people who make the boxes, in the Bell Canada case, invoke the common carrier exception again. They say, well, we're not, helping people infringe copyright. We're Facebook. We're not copyrightinfringement.com, right? We make the boxes, and then these people, being as imaginative and mischievous as they are, download the software and decide to infringe Bell Canada's stuff, right? And what happens? Well, the court says no. And why is that? Well, the court says two things. First, as I told you, the exception is displaced. As I told you, the exception is displaced when the host is in the coup, when the host is not content neutral, the host or the intermediary, right? In that case, they're making boxes. That's the intermediary. The box is in the middle of the person watching TV and the copyright owner, and they provide the means, right? And why in that case is the common carrier exception rebutted? Well, the answer is because they're in the coup. And so they don't really just provide a box, right? And one of the indications of that, unsurprisingly, as I told you, is they make money, right? They make money from boxes that do copyright infringement. That's a strong prima facie indication. And what else do? Well, they do all these weird things that they should have known was not going to work out when they went to court, right? They do tutorials that show people, hey, when you buy this stuff, right, do this, and you'll get copyrighted stuff for free. So they're in the coup. What else do? Well, they market their boxes as copyrightinfringement.com, right? They say, take this, and you will watch television for free for the rest of your life. And that is being in the coup. That's authorizing the violation, participating in the violation, and they're responsible under the principles that we saw before. Last issue in that section, up to page 189, you have section 31.1 of the Copyright Act. that was amended in 2012. And what does that say? Well, it codifies what I've just said. So it adds the exceptions for internet intermediaries, for caches on the statute. But again, doesn't create them. They weren't created in 2012, right? They were developed by the courts, but they were clarified and added to the legislation for greater certainty and to make sure it applies to all the cases in the future. And that was done in the 2012 amendment of Section 31(1) of the Copyright Act.